The case is now being recorded. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you very much, Matt. Good morning to you all. Welcome to the Massachusetts Appeals Court. My name is Judge Desmond. With me on the panel is Judge Ditkoff and Judge Englander. Will be the panel for all three cases this morning. Our first case will be conducted virtually via Zoom. After the first case, we'll take a brief recess and we'll go down to the courtroom for the remaining two cases. The first case on our docket is 23P1440, John Doe number 176782 versus the Sex Offender Registry Board. Attorney Hernandez.
Good morning. May it please the court. Attorney Xiomara Hernandez for the plaintiff appellant. I'm here today requesting this court lower my client's classification level from a level 3 to a level 2, or to remand the case back to the board for another classification hearing. The classification decision was arbitrary and capricious and an abuse of discretion where the hearing examiner erroneously found that my client committed a rape. The finding
Attorney Hernandez, let me ask you this question.
Sure.
If we find that the hearing examiner's conclusion that your client did commit a rape of victim 2, does that undercut your argument with respect to the other factors that he applied in light of that finding?
So if you were to find that the hearing examiner erroneously found that my client committed that rape, there are a couple of risk elevating factors that the hearing examiner applied, and I would say in error.
My question is, if he didn't apply the rape erroneously, then do those other arguments fall?
If he did not, they do, yes.
Okay.
Yeah, or at least the factors that I indicate in this argument section, those would fall. It would be okay for the hearing examiner to apply those factors. And I would say the reason why the hearing examiner made this error in finding that my client committed the rape was based on the unreliable hearsay that was contained in the police report. If you read the full police report, there's a lot of details regarding the prostitution itself, but there's not a lot of details regarding the rape itself. The person was unclear on the date that it happened. The person was not specific in terms of what room within the hotel that it happened. And if you read the facts, the person didn't even indicate much information regarding the rape itself. He only writes, or the report only indicates that he said that my client forced her to have sex. There's no details regarding what that looked like.
And in this instance, the person is a 17-year-old?
No, she was an adult.
She was an adult at the time?
Yeah, she was an adult, yes. There was also no witnesses and no physical evidence. I know that the hearing examiner wrote in the decision that she reported it to her friend at the clinic. But if you read the police report on page 143, volume 1, the person that spoke to the police did not say that the woman indicated that she was raped, only that she was kidnapped. There's no indication in the police report that the friend told the police that she told him that she was raped. He only indicates that she was kidnapped and needed help getting away. And also, after a jury trial for this rape, my client was found not guilty. And I understand that the standard of proof is different, but that means something in this context. You know, especially if you see the police report, there's not that much details regarding the rape. So not detailed, based on hearsay, and then also found not guilty. And I would contend that as a result of that erroneous finding that my client committed the rape, the hearing examiner applied 2 factors in error. In my brief, I argue that he applied 4 factors in error. I'm actually going to concede that it was an error to apply factor 2, repetitive and compulsive behavior, or factor 22. But I would say that it was an error to apply factor 19, which is the level of physical contact, and factor 20, the diverse sexual behavior factor. So I would say that first, it was an error to find that he committed the rape. And second, it was an error to apply those 2 risk elevating factors to this case.
And you
And I would,
think, and it's your belief, it's your argument that now, given that it's not 4 factors, it's only 2 factors,
Mhm.
that it would still result in a lower classification.
that in combination with the other arguments I have in my brief, I would say that my client should have been classified at a lower risk factor.
So
And that's,
counsel,
yes,
the hearing examiner also cites to the Commonwealth's statement of the case, which is a document that was filed in connection with the trial, I believe. And that contains more detail regarding the alleged rape. What do you say to the hearing examiner's reliance on the Commonwealth's statement of the case?
well, again, I will say, so it contains details in terms of that, I believe it said that he smacked her at some point, grabbed her hands, but again, there's no details regarding how he raped her. You know, the hearing examiner assumed that the rape consisted of penile and vaginal, but that was an assumption. There's no indication in the police report or in the Commonwealth Statement of Facts how the rape occurred.
Do you think it's valid for an examiner to rely on a pleading like this as a report of the victim's statements?
Yes, but again, there's not that many details regarding the rape. So that's what I would say, that the fact that there's not that many details regarding the rape, and also the fact that he did go through a trial, and after the trial, the jury found that he was not guilty of that rape. And I would also say that the hearing examiner made a mistake by neglecting to give full risk mitigating weight to factor 34, which is stability in the community. As you'll see in the record, my client was involved with stable housing at the time. He was living at the Brooks House, which is a pre-release reentry program. He had stable employment as he was working at the time. He was seeing a case manager at the time as well. Excuse me. He was involved in AA meetings 3 times a week, and he was involved with mental health treatment. So I would say with all of that, the hearing examiner should have given this risk mitigating factor full risk mitigating weight instead of moderate, which was the weight that he gave it. And I would also assert that the board did not meet its burden of proof, which is by clear and convincing evidence that my client poses a high risk of reoffending or danger to the community. My client last sexually offended in 2013, over a decade ago.
Was he on probation when he offended?
He was on probation when he offended. Yes, he was. But again, he hasn't reoffended since 2013. While he was incarcerated, he did adjust well to incarceration. He was involved in many programs and received many certificates of completion from the programs he was involved in. Also, he worked while he was there. Risk mitigating factor 28 applies here because my client was on parole and doing well on parole. Risk mitigating factor 33 applies here as well. He's had the love and support of the community and many family members who submitted letters of support on his behalf. Risk mitigating factor 30, advanced age, also applies here, as he was 40 years old at the time of the classification hearing. And according to the regulation, 40 years old, that age is the time that the risk of reoffending begins to decrease. And lastly, risk mitigating factor 32 fully applies here, as my client was involved in and completed sex offender treatment. For these reasons, I would request that this court lower my client's classification level or remand the case back to the board for another hearing.
What, counsel, what factors do you think fall away if there is an improper finding of rape?
I would say 2 specific factors, which is factor 19, level of physical contact, and factor 20, diverse sexual behavior.
Just those 2?
Just those 2.
So why is the level of physical contact not established by references in the police report to the fact that your client forced the victim to have sex with others. Why doesn't that establish a level of physical contact sufficient to have factor 19 apply?
Well, the hearing examiner applied this factor because he indicated in the decision that he applied this factor because of the rape itself, not because of the other behavior. So I would say if the rape were to fall away, then according to this hearing examiner, this factor would not apply.
Put another way, would you agree that forcing the victim to have sex with other men does involve physical contact?
Not with my client. Obviously it involves physical contact with somebody else. But again, according to the hearing examiner, he did not apply this risk elevating factor because she was forced into prostitution, rather because he raped her. So that would be my argument in regards to that. And if there are no further questions, I'll rest on my brief.
Hearing none, thank you very much. Very well argued. Attorney Shania.
Thank you. If it pleases the court, David Shania for the board. The board's position obviously is that it was reasonable for the hearing examiner to rely on the statements made by the victim in this case and to find that this individual was in fact raped by the plaintiff, physically raped by the plaintiff. And the reason for that is twofold. The most important being that it really was, if you look at the entirety of the woman's statement, which was confirmed, some of it which was confirmed by this woman, Jazzy, the whole statement was about this individual, the plaintiff's emotional and physical control of this woman over a 2-week period to force her into prostitution and to continue to force her into prostitution. And that included degrading her, physical violence towards her. And it would be reasonable for the hearing examiner to accept the fact that this individual also used sex or at least rape of the woman as another tool in degrading her and forcing her into prostitution.
Sure. Is there anything in the police report that indicates that she says she was raped physically by him? And if so, point to it, please.
It's not in the police report. Actually, she says that in the police report, she told the police that he raped her. I believe in the, I think it might be on page 158 of the exhibits. But she specifically said that this individual did rape her one night in the, because he wanted to test the merchandise, is what he told her.
That's not in the police report, counsel.
Okay, that's my memory of the police report.
No, but I mean, it's important, it seems, and I know Judge Ditkoff has some questions about this too. I don't want to jump in and, Judge Ditkoff, did you want to ask?
So you've done exactly what the examiner did, which is you've jumped into the statement of the case. You're off the police report. And so I'll ask you the same question I asked your friend, which is, why is it reasonable to rely on a statement of the case as if it were the victim's statements? It doesn't say the victim said any of this.
The Commonwealth's statement of the case is a written statement of the case which is submitted to the court. And I would presume, as an officer of the court, the district attorney who submitted that would not be putting falsehoods or misstatements in the Commonwealth's statement of the case.
Isn't a statement of the case what the Commonwealth hopes it can prove at trial and expects to prove at trial? But we know, the one thing we know for sure is that as far as the rape happened, it didn't prove this stuff at trial. So how do you rely on that as details, as information that allows you to find the rape occurred?
First, you got to remember that the hearing examiner only has to find by a preponderance of the evidence that it happened. Doesn't have to prove beyond a reasonable doubt or even clear and convincing evidence that the rape happened. It's so I think based on taking the inferences that were made by the woman's statement the hearing examiner could reasonably rely on that and infer that a rape did occur.
Which inferences? Which inferences specifically?
That the woman
Statements.
Which
The-
one?
that the woman told the police that he raped her. She didn't use the words raped, but that he physically assaulted her and wanted to test the merchandise and forced her.
Okay, well, how do we know that she said that he said he wanted to test out the merchandise?
Because that's what she told the police.
How do we know that? What says she told the police that?
I believe it's written in the police report.
So where? Point to it, please.
Yeah, I didn't see it in the police report.
Yeah, I thought I saw it in the police report.
Well, if I could, the police report, I'm on the 5th line of the 2nd page, and it says, and this is the only thing that I am, at least the only one I could find this morning, the second hotel, which was said to be located on Wood Road, was where the plaintiff forced the victim to have sex with him for the first time.
Correct.
So that there's one sentence in the police report. In what is otherwise a very detailed police report, there's one sentence about rape. The statements, one of which you alluded to earlier, about she's his property and he has to test the merchandise. Those statements are in the statement of the case, but they are not in the police report that I can see.
Okay, that would be fine. It's still the overall.
Well, the question is whether it's reliable hearsay, right? That's the question under the law.
Right.
Sufficiently reliable to be relied on by the hearing examiner. Is it a statement by an advocate in a pleading to a court, which doesn't even say it's quoting the plaintiff? I'm sorry, it doesn't even say it's quoting the victim. We're going to credit that as sufficiently reliable hearsay?
Well, that's what the hearing examiner relied on. And the question becomes here today whether or not you agree with that reliance. Even if you don't agree with it, I don't think it changes the classification in this case. The individual, it's only 2 of the factors. And more importantly,
is it 2 of the factors or is it just the one factor? Does the factor physical contact, is that established by evidence to the fact that he forced the victim to have sex with others, not with him?
Well, the thing about factor 19 and my memory is my always belief of factor 19, it's a contact sex offense involving the sex offender himself. I don't think it extends out to forcing someone to do other sexual acts. I think that's encompassed in different areas of the analysis. But the fact that, it is a enumerable sex offense registered.
Because I think under our law, forcing someone to have sex with someone else can be rape. And in fact is.
Correct. I'm just not sure that fits under factor 19.
Okay.
The way 19 is researched and put together, I don't believe factor 19 extends to forcing someone to have sex with others. I think that's more of a direct contact sex offense between the offender and the victim. I mean, I'd love if we wanted to expand it out, if this court wanted to expand it.
I'm just asking the questions. I'm just asking the questions, counsel.
Do you think, Attorney Schneider, that there is a factor that speaks to a rape as outlined by Justice Englander, where he's forcing her to have sex with somebody else? And if so, what factor would that be?
I don't think there's this factor specifically on that. I think the fact that that type of behavior, this like the conviction in this case, outside of the rape allegation, was suitable, would have been on its own a registrable sex offense. And looking at the scope of someone's sex offending behavior when that individual is committing non-contact sex offending, which would be the case in this situation, forcing someone else to have sex with others, is part of probably under a factor 37, part of the whole analysis of someone's sex offending behavior overall. I don't think that there's a specific factor that directly deals with this type of sex offending behavior, but the legislature has required that this type of sex offending behavior be a registrable sex offense and part of a classification process. So I think that that's encompassed within the sex offender statute and within the overall classification analysis of an individual, because it is a pretty heinous type of crime. In this case, and why I'd say that the rape allegation itself is tangential in the sense that, in 2005, this individual preyed on a 17-year-old and forced her into prostitution and gets convicted for that. And then 8 years later, does it again with a 25-year-old woman. And there's also indications in the police report that he tried to control other women along the way, including employees at the hotels that he was using for prostitution, to try to get them into prostitution on his behalf. I think that there's a sense that he's preying on individual women that he meets, who I believe he feels are vulnerable. In this case, this woman, a 25-year-old, was someone who was homeless, had lost custody of her children. That's kind of the inference you get through the police reports, with him telling her if she goes into prostitution with him, she'll have enough money for an apartment, she'll be able to get her kids back. I think that that's the type of behavior that the registry is designed to warn future people about, future possible victims about that.
So you say that the rape is tangential to the kinds of conduct that cause a level 3 here. That was the word you used. But we do have this issue that there are really 4 factors that are identified, and 2 of them fall away without the rape. What would, if, just assume with me, because I'm not suggesting that I've come to rest, or any of us have come to rest on this, but if there were insufficient reliability for the rape, what would be your position as to whether the level 3 classification could stand?
I think it stands because of, again, taking the rape out of the equation, you still have an individual who twice forced women into prostitution. One was a 17-year-old girl, the other was the 25-year-old adult woman. And in the 25-year-old woman, what's even more heinous about it is the behavior that he exhibited in controlling her life, giving her drugs to make sure she'd be active for prostitution, setting her up on, putting her in a hotel room and not letting her leave the room, taking away her medication and that she needed to take, and then taking her to the methadone clinic, waiting outside. I think what's telling is when she tried to escape and the individuals helped her out the back door of the methadone clinic, what he said was to these individuals was, "She's my property." So I think that there's a level of aberrant behavior towards women, forcing them into sexual servitude for himself, for his benefit. I think that makes him 3 at this point, considering that he did.
Counselor, I can see how you could get to a level 3, but where the examiner mentions the rape in 3 different factors, how can we be confident the examiner would have gone level 3 without finding the rape?
I think we're getting back to 22188 all over again, Justice Davis.
Yeah, but I wrote that, so
I know.
that's all now.
And I think that the facts of the matter, still, regardless of the hearing examiner's analysis of that rape and its application of 3 factors, I think the overall state of the case still supports the level 3 because of the fact that this individual, the types of crimes he committed, the fact that, I understand his last one was in 2013, but he'd been incarcerated for almost 8 years of that time, since that time. So, and right now he's living in a very supervised situation, but, that's not going to be forever. So I think that there's risk here that puts him at a level 3 based on his behaviors outside of the rape, outside of the fact that the hearing examiner said factor 19 was applied, which goes to dangerousness, and factor 20, which goes to, I also believe 20, I think, goes to both dangerousness and risk. But I don't think that taking those two out of the equation changes the state of this case, as it applies to the fact that he was a level 2 in 2008, and then committed these offenses a second time. I mean, at some point, you have to say, what do we do with an individual who not only gets convicted of a sex offense, of a type of sex offense, then gets classified, and then after doing his time in jail and his probation, commits the same exact sex offense?
Or perhaps worse.
Or worse, in this case,
While on probation.
while on probation. And I guess that would be the Commonwealth's case. I'd be willing to rest on my brief and not such any other specific questions.
Hearing none, Attorney Chennai, the matter stands submitted. Thank you both very much. We'll
Thank
argue
you.
on both sides.
Thank you.
Thank you. Take care.
We'll now take a brief recess as we assemble in the courtroom.